So I'll call the meeting to order. Looks like it's 10:45. And now we will begin the public comment section of the business meeting. This is an opportunity for members of the public to address the commission on matters of public concern. Please refrain from using this time to discuss disciplinary cases or topics currently covered by the commission's rulemaking or policy initiatives. If you'd like to comment on rules of development, please see our rules in progress page on our website to ensure your input is considered in the rulemaking process. We also encourage you to participate in our rulemaking workshops and hearings. To provide feedback on commission policies, guidelines, interpretive statements, you can comment during one of the upcoming policy interested parties or policy committee meetings. The schedule for these meetings is available on our website under policy meetings. Additionally, the public may contact staff during normal business hours, and we welcome written comments at any time. Please note, we will not be answering questions or responding during this period. Staff will be available after the meeting to assist with any inquiries. Each speaker will have 2 minutes. When it is your turn to comment, please state your name and any affiliation. Would anyone like to provide a comment at this time? Ms. Boyd, are there some people who wish to provide comments?
There's no one signed in, but we do have one hand raised. So Cindy, if you would like to go ahead.
Yeah, thank you very much. Good morning. My name is Cindy Hohenhaus, co-chair of Washington Patients in Intractable Pain, or WashPIP. We advocate on behalf of Washington patients living with intractable pain for access to appropriate pain care. We ask for representation anywhere opioid policy or actions are discussed or created. Thank you for the opportunity to comment today. I'm deeply grateful that the Secretary has moved forward our proposed amendments to the opioid prescribing rule interpretive statements. The Secretary's changes meet the intent of our proposals. We hope the amendments make clear that the myopic focus on morphine equivalent dose and the resulting reckless tapers are unacceptable. Tapering should only be initiated for reasons listed in the Washington opioid prescribing rules and for the health and safety of the patient. However, MEG ceilings and tapering have become an act of self-preservation brought on by the treating physician or facility. Patient outcomes can often be irrelevant. This has never been the goal of the Washington opioid prescribing rules or of the Medical Commission. Thank you for taking the initiative to clarify the rule's intent, which is to protect the health and safety of Washington patients while effectively treating their pain. I would ask that you generously continue to move forward and approve the amendments. Thank you so much.
Thank you for your comment. Anyone else, Ms. Boyd?
It doesn't appear so, no.
All right, this concludes the public comment period. Looks like the next part of the agenda deals with the chair report. This is my last business meeting I'll be running, and I just want to make a few comments. First of all, it's really been an honor and privilege to get to know all of you. I think we all have different backgrounds and different interests, but I think we're all here to be able to improve patient safety in our state. And so again, it's just, and I appreciate, your comments and all your expertise that you have. And so it's been fascinating, especially as someone who's worked my whole career in patient safety. But it's often been very specific to the field of anesthesiology and pain medicine. And to have the background of public members and other physicians in other areas has just been exceptional. I wanted to make a couple of comments about things that I thought were most interesting during the time that I've been here. I joined on the commission right at the time where Dr. Roberts, who was the former chair surgeon, and gave us all books, which is on Dreamland. And Dreamland is written by an author named Sam Quinones. He actually saw him at the American Society of Anesthesiologists meeting. He was the last October, and he was the keynote speaker. And this is really the tale of the American opioid epidemic, and particularly starting with the OxyContin, the treatment of pain, and then fentanyl. And I thought that was just, and you know, it's something we've been dealing with, and it's something you see has been dealt with in the whole country. And if you think about the areas, I'm from Michigan originally. I lived in Pittsburgh for a period of 3 years. And those are the Rust Belts. And you look at those sort of communities and you can see they've been devastated. Dreamland was written about in Ohio and the loss of these jobs, you know, in manufacturing that has had occurred in those areas. And it also, when I moved to Washington State, when I was recruited to work at University of Washington at Harvard Medical Center, that it is a problem in our state too, with the fishing industry and the logging industry. So I thought that was important because it sort of reflects on our you know, what's happening in our country and trying to deal with it. The other thing I thought was really interesting as well and informative also is timely, deals with the issue of medical misinformation. And that came up during the COVID era. I know we all who've been on the commission since that time have experienced that. And it is, attended the FSMB meeting, and many of you did. And I thought the whole discussion about medical information and why this is occurring. I think when I grew up, I'm from Michigan. I watched actually CBS, Canadian broadcast system, but there was NBC, ABC, and CBS, and the Canadian system where I had for TV. Now we have social media, we have all sorts of platforms, and what happens is no one hears the same news. We all hear different versions, and it creates, with the social media and the press, of what's really exciting, right? Development, that's some new thing that has no testing, just is anecdotal, gets high excitement, whereas scientific studies that are done, clinical trials over things to prove their worth, gets very little reporting because it's not exciting. And I think those two things have really affected me in my time on the commission, is seeing both of those things operate, how it has affected, I think, our current political situation. The two things I thought were great that we did, just as somebody who learned from, has been involved in patient safety a long time. I was an early reader of basically To Err is Human, which came out of the, now it's called the National Academy of Medicine. I actually did a fellowship there years after that, 10 years ago. And it really talks about that we want to, we work in systems, and there are systems that lead us to have errors. And what we want to do is not just blame the practitioner for making that error. That's a practitioner, a nurse, a PA, anyone, an aide, anyone taking care of patients. There are systems there that make it conducive to having an error. Example one I just want to share is when I worked at Harborview, and I was Harborview, we call affectionately the zoo. It's kind of crazy. I really enjoyed trauma. I really enjoyed trying to resuscitate patients who are severely injured. And I remember being in one case where I think we were probably, it had at least 40 or 50 units of blood transfused. The patient did survive. I work in teams, right? We had residents. I think I may even enlisted our anesthesiology assistants who also, I think at the time were certified to check blood. And then I went on, after that night on call, I went on vacation. And then I get an email saying, oh, Dr. Domino, you accidentally gave 2 mismatched bags of blood. Now, the patient had no harm because it was somewhere in that process, right? And he exsanguinated, so there was no notice about it. I was leading the team. I wasn't personally checking this because it's just bad, trying to keep this patient alive. But that is a system thing, right? In doing it, you can look at all the things that go into it and why that might have happened. And it is, of course, a never event. So I think, having that kind of program, I think the CRP process, and I think having that or investigation has really been great because it can help pick out systems issues. As an example, wrong side surgery is a system issue. However, if you have the nurse and the anesthesia provider saying, hey, you're on the wrong side, and the surgeon decides, I'm just going to do surgery on that wrong side. That is an individual issue, but in general, you have to view things within the context of that. And I'm glad that we are getting that, and thank our investigators for being able to get that kind of information that we have. The other thing I think that's been really a great development that we've had is the practitioner support program. And, I participate in the CMT as much as I can. And we see so many issues relating to communication issues, medical record issues, things like that, you want to give someone, at least try to educate them, at least on the first step when they're having problems with communication, of how can you really communicate better with your patients, especially in difficult situations. And I think that's been a great program as well. Yes, we give them that opportunity to learn from that. If they don't learn from it, then these things will actually come to us for further review. But I think that also is an educational thing, parameter. So just want to say, I thought those things that we've done have been really exceptional. I appreciate all of your collegiality, the whole team, and thank you so much. Bye. Bye. I was going to say bye. Oh, I had one other comment. I sit here with the USMLE, so I did attend that conference. What they're really interested in is to have that board members, including public members, participate in the USMLE process. It's very involved. I know I worked for the American Board of Anesthesiology for a long time, writing, written questions, which are terrible. Type A, right? Type K questions. They're very difficult, but they want public members. They're looking as well as physicians. They're looking at board members as one to try to pinpoint areas I think would be in the part 3 of the exam to dealing with patient safety, dealing with ethical issues, the kind of things that we see as board members in that process. There are various amounts of effort you can do. There are meetings there, and there are some that oversight committees getting down to some who are doing more of the writing of the questions. There are also questions that I think analyze scientific, look at how the candidates can analyze scientific information from an article and interpret things often, and as they say, ethical, patient safety things. These are the type of things that are explicitly interested in board members being involved in. And if you are interested, please contact me. I'm going to try to get a little more information from them. And because they did have a whole thing about what sort of the opportunities are, and I'll probably send out to everybody, but I thought it was an interesting conference to hear about that, and to learn why they wanted to involve board members. So just putting a plug for that. All right. Consent agenda. All right, we had 2 items on the consent agenda. These include approval of the May 9th, 2025 business meeting agenda, and the minutes for approval of the March 14th, 2025 business meeting minutes. Can I have a motion to approve these on the consent agenda? Anyone?
So moved.
Okay, second.
Second.
Great. All right. All in favor, say aye. Anyone opposed, say nay. Okay, the consent agenda passes. All right, new business. Petition for declaratory order. On March 11, 2025, the Washington Medical Commission received a petition requesting clarification of licensing requirements for independent medical examinations. Commissioners must now consider whether to issue a declaratory order in response and vote accordingly. Amelia or anyone, can you tell us what about this?
I think
Kyle?
it's Heather. I think it's Heather.
Heather. Okay, Heather, sorry. I didn't-
No problem.
Yeah.
No problem. So in your packet, I wrote a short memo just giving you some of the background information on what a declaratory order is, what are the standards for it, and then some of the laws that might be applicable here in this situation. So you did receive this request from Dr. Penner. Under the Administrative Procedures Act, which you must comply with, you have to make a decision within 90 days. You asked to set this over to this meeting from your last meeting so that you can collect any public comment on the issue and then make a decision today. It's my understanding that emails went out to the listserv requesting public comment as well as notifying Dr. Penner of the decision to bring it to the meeting today. To my knowledge, no written comments have been received. And so at this point, I think you should open it up, see if there's any comments in the audience today, and then this discussion and decision.
Anyone have any comments? Discussion? Anyone?
Okay, so just to sort of reiterate, a declaratory order is an order that the commission would issue declaring how specific circumstances would be approached as far as the laws that you enforce. It requires that there be some uncertainty as to the law or the applicability of certain circumstances to the law. The petitioner needs to show that they're adversely affected by this uncertainty. And they need to provide specific facts sufficient enough that you can actually render a binding decision. It can't just be that you're giving some advisory opinion as to how maybe you would look at this or what it would be if it were this circumstance or that circumstance. They need to provide specific circumstances. That's because this order, if you decide to issue one, has the same effect as, say, your disciplinary orders. It's enforceable because for that person, and they can rely upon it as a legal basis to say if the law applies to them or not. In this case, Dr. Penner is asking whether an independent medical psychiatric examination conducted over telemedicine constitutes the practice of medicine and therefore necessitates in-state professional licensure for an evaluator examining the subject individual present in the state of Washington at the time of evaluation. So when looking at this, in my opinion, I'm not sure that there is sufficient specific circumstances that you can provide a binding decision on this. I think there are still questions on what is the IME that he's talking about? What purpose is it for? There are lots of different IMEs. There's injured workers, there's expert witnesses in civil cases. There's all sorts of different IMEs. So I think you would have to know those facts in order to issue a decision. I also don't think Dr. Penner showed that this perhaps uncertainty affects him or is it adversely affecting him? I don't know the circumstances of that. Generally, I would say that in state law, when you adopted or when the compact was adopted, the standard that the patient is located in Washington and a physician is providing care to that patient, that they must be licensed in Washington. So that's a prevailing standard, but was codified when the compact was adopted. There's also, the wrinkle with telehealth. So there's also the Uniform Telehealth Act, and I cited it in here, and you used to have a policy that stated this, but then it was codified again by the legislature that talks about, second opinions, consultations, those things don't require licensure in the state of Washington. So a out-of-state physician could help consult with you to provide a second opinion without having licensure here. So you need to decide whether or not the petition was sufficient to issue an order. If it was not, then we need to state the reasons why, and that can be done through a letter. But you can discuss those today so that we can draft a letter to be sent. If you decide that there are sufficient circumstances and it is adversely affecting him, then you can issue an order that says yes or no, licensure would be required. There's also another thing to consider, which is you don't, the commission does not prosecute unlicensed practice of medicine cases. Those are brought by the secretary. So that's another issue here where I don't know that you can conclusively say the license is required when it would be the secretary that would be making that final decision. Any questions, I guess, before we start discussion here?
Yeah, I guess just maybe a point or a question for clarification. I guess I'm trying to understand why this is different because it's an IME question as opposed to just standard practice question. Because if we already answered that from a standard practice question, why are we asking it for an IME question?
I think that is a good question. In my mind, it seems to be that maybe they're thinking this IME somehow isn't being used for care of the patient. Is it some way being used, say, for an expert witness or that's a good question. And I think that's another reason why maybe the specific circumstances aren't set up to be able to answer that question. I mean, I think you can generally say if you're providing care to a Washington patient, you need to be licensed here.
There's also currently, I know that with some of the psych telemed issues that we have going on right now on the payer side, we have a group of psychiatrists that want to get credentialed for various hospitals that we have. And when they see the patient and do a psych eval, they have to be licensed in the state where they're doing that from in order to get paid. So right now we're struggling with a payer side of that. So I'm not sure if this has a lot to do with that as well. But in order for the provider to provide that practice for us, if they're in North Carolina and they're seeing a patient for us here in Washington, we have to know their actual address, where they're coming from, the TIN number, all these things are changing. And I believe the legislature with, that is going to happen like in, I think, 2026, it's been stretched out, where the whole payer issue is going to come crashing down a little bit for this. So we're also looking at it from a credentialing standpoint. This might fall into that same category. Just
Are there other comments? Those of you who are virtual? So Heather, we're supposed to take a vote on whether to issue a declaratory order.
Correct. So you need to vote either to decline to issue an order and state the reasons why, or to issue an order and to, say whether or not, answer his question, whether or not licensure is required.
Yeah, okay.
I move that we do not issue a declaratory letter because he has not fully outlined what he is asking. An independent medical exam could be anything from LNI to telemedicine, and that is the practice of medicine. Psychiatry, we realize psychiatrists are doctors of medicine, and therefore what they carry out is the practice of medicine. So he has not outlined that it's not the practice of medicine in any way, shape, or form, and he has not indicated exactly what the hardship would be. So I recommend we do not.
So I will take it as a motion. We already had a second. Anyone have you have any comments about it?
I guess I do have a comment, which is just looking at the original memo from the doctor, very specific in asking the petitioner respectfully requested that, well, Washington State Department of Health doesn't say Washington Medical Commission. So that, I guess that's one potential point, issue a declaratory order determining whether and I conducted over telemedicine constitutes the practice of medicine. So whether or not this impacts the petitioner one way or the other, if we were to declare an opinion that IMEs are over telemedicine are, that does constitute the practice of medicine, does that constitute a declaratory order?
So you would, sorry. So the declaratory order would have to apply to the specific facts that he's set forth. So absent those specific facts, again, that's why it's so, or it's difficult or almost impossible to issue an order that would be binding, because you're lacking some specific facts that you would need to know to make that determination.
Okay. Well, in that case, I would support Dr. Murphy's.
Any other comments or discussion from commissioners? So I guess we should take a vote. The vote is how many people wish to decline the declaratory order? Say aye.
Aye.
Anyone opposed, say nay. Right, we decline that order. All right, the next thing, looks like this, Kyle's going to present a letter from Eli Lilly.
Point of clarification real quick.
Yes.
What will the response look like and who will it come from?
So you voted to decline it. It will be in a letter form, and it will just set out this procedure. And then I've taken notes today about sound like that, not fully outlined what he's asking, lacking sufficient facts, not shown how it impacts the practitioner or that there's a hardship, including the fact that it should come some of it from the Department of Health. So that can be put in a letter to be signed by the chair.
Thank you.
Okay, Kyle, the letter from Eli Lilly and Company.
Yeah, I hope folks had an opportunity to review what the folks at Eli Lilly sent us. I wanted it put in front of you because it was asking for commission action. I'm happy to go into the details here too.
Why don't you summarize it for everybody?
All right. In essence, for a period of time, the US FDA had declared a drug shortage for a particular kind of medicine. And it includes an active ingredient, tirzepatide, I think I'm pronouncing that correctly. It is in two patented drug formulations of Mounjaro and Zepbound. Those are GLP-1 medications that are designed to help people either alternately with diabetes and weight management, but also sleep apnea. The FDA in March rescinded that drug shortage notice. And so during that interim period, there were people who were permitted to compound and formulate the drug outside of the brand names that Eli Lilly has applied to them. With that, that means that those drugs are once again proprietary and can only be formulated under either a patent agreement with Eli Lilly or elsewhere. And so Eli Lilly, in essence, again, the letter's quite long, is looking for the commission's assistance in enforcing their patent on those two medications. They have not provided a complaint. So we don't know if there's a doctor who's out there compounding these drugs. This is largely really more an issue for your colleagues on the Pharmacy Commission. We do have at least one case that's out there in investigations involving something in kind of tertiary involving this. But I wanted to bring it forward. We are under no obligation to respond to that, but I wanted to give you that option. I don't think that it warrants a response. it's not really within our regulatory bailiwick. If there is a specific physician or PA who's out there compounding these outside of Lily's patent rights, we could certainly take a look and investigate. I know that they filed civil suits against several people. I'm not sure if any of them are in Washington or not. Several physicians who are advertising that they can provide these drugs under using the patent name to patients. But again, it makes me uncomfortable when we get requests for commission action like this to summarily act on my own. Hence the reason I'm bringing it to you. I'm happy to answer specific questions. But I don't think that there's a need for action. There's not a need for a vote unless you all want to take action and you want me to send something back to council and you would.
Kyle, this is really, the compounding is really a pharmacy issue, is it not? I mean, so I know individuals, practitioners compound like an anesthesiologist as an example, who works in the OR, and they consider compounding if you put saline into the vial that you have in your business machine and give it to a patient. But this, my understanding is on a widespread scale, and that individuals, yeah, sure, we could go after individuals, but I thought this is not, these are big groups.
I would agree on all counts. Again, I know that they have also sent this to the osteo board. I also know that they sent this to, I believe, the nursing board, because ARNPs can technically compound. But they've sent this to the pharmacy commission. My last conversation with my colleague at the ED at the pharmacy commission is that they didn't pursue or take action.
My comment would be, our system is a complaint-driven system where we don't look for issues. And until we have a complaint against a physician or a group, I don't think we have any action at this point. I think we have enough good work to do.
I agree.
And I would encourage the pharmacy commission, if they see fit, to pursue it, because I think it's mostly in their domain.
They have taken action against one large operation in Washington. They issued kind of a temporary stop, and that wasn't based on patent infringement or intellectual property rights. It was based on public safety issues. As I mentioned, we've got cases of investigation that are kind of tangentially involved that I'm not going to difference, but point taken.
Great, so we don't really have to take a vote. Any
Just a
other
quick comment.
people comments, yeah.
Yeah, sorry. No, I would, yeah, just to add a little bit more, maybe slight color to this, I think. While most of us, I think generically feel like, pharmaceutical companies are not to be trusted, any further than we can throw them. But to be fair, I think what they're pointing out are actually things that we should keep in the back of our minds. One is that these drugs are actually FDA approved for diabetes control, not weight loss. I think we do have to consider that if there are physicians who are pursuing or marketing these drugs specifically for weight loss, and a complaint comes to us from that perspective, we'd have to take that into consideration. Not necessarily saying that that's a wrong thing to do, because doctors use these on people all the time, but just to say that in a way, I think it is a little bit of risk deflection from the pharmaceutical side, that they want to make sure that whatever comes back to that, they can always just say, well, it's only been under the approval for diabetes, not weight loss. So it's up to the physicians, and I think we probably need to be aware that that's their stance. I think their point on compounding is obviously it may be a pharmaceutical issue. They do point out some specifics of like vitamins and other things to it, which might be harmful. And if we do get a complaint from physicians doing that, or working with pharmacies that do that, we can take that into consideration. So I would agree that I don't think it's necessarily asking for a response, but there are some specific points that we probably want to take into consideration.
Looks like Dr. Curry has her hand up.
I just wanted to clarify that Zepbound, one of the drugs that they are referring to at Eli Lilly, is actually FDA approved for weight loss. And most of the compounding that goes on is for patients that can't get their insurance to cover the medication for weight loss, since most insurance will cover for diabetes. So that's actually the target sort of audience for this. That's all. Clarification.
Any other discussion?
Yeah, I just want to second Dr. Clarissa, but basically it's just play for words because Zepbound is actually just Zepbound. So having prescribing those, I understand that it's the same medication, but they just use it different brand name and apply for FDA approval. So while the Mounjaro is specifically indicated for diabetes, but the same drugs Zepbound from the same company is applied for weight loss.
Any other comments? No. All right. So what do we need to do with this? Nothing? Other than discuss it?
Move on. Next up, the agenda.
Okay. So we'll move on to old business. There are written reports on page 138 for the committee work group reports. Are there any other additional reports or any discussion of reports that were given? Seeing none, we have rulemaking activities. This includes, it's provided on pages 141 to 142. The pre-proposal statement of inquiry or CR 101 for opioid prescribing general provisions for MPs and PAs was filed on April 30th, 2025 as WSR number 25-10-039. Amelia Boyd, program manager, requests volunteers from the commission to serve as panelists for this rulemaking effort. At least 3 commissioners are needed to participate in upcoming workshops, which will be scheduled soon. So, Amelia, do you want to say anything more?
Just that I do need some volunteers to serve on those rulemaking workshops. The only reason we set up a committee for when we have a rule is so that I have like a first choice, so that I can reach out to like 3 or 4 commissioners and try to mesh their schedule together so that we can schedule some workshops. So if anyone's interested in working on that rulemaking effort, you can email me and let me know you'd like to be part of that committee.
Okay. Next thing, interpreted statement, qualified physician under optometry law. This document has been completed. The Department of Health Secretary review and minimal changes were made. Commissioners will meet to review and consider approving the following for adoption. Interpretive statement, opioid prescribing and monitoring for allopathic physicians and physician assistants. And it's completed the Department of Secretary review.
So the
Any
first,
edits to that, or so I can't tell what's so confusing here.
so the first one is the interpretive statement for qualified
Oh, I
physicians
see.
under optometry law. They made some like minor changes, so our ask here today is whether you would like to adopt it as presented in the packet.
Do we need a vote on that?
Yes, please.
All right, any discussion about that? Can I have a motion to basically recommend that it be approved as modified?
I so move.
Second? Second. All in favor, say aye. Raise your hand. All opposed, say nay. April, do you have a?
That's how she votes,
Yeah.
yes.
Okay. Great. All right, we'll move on to the other one and that passed.
And this is the interpretive statement for opioid prescribing and monitoring for allopathic physicians and physician assistants. And it also has completed Department of Health Secretary review. And we need to review and either approve or deny the suggested changes. And that, any comments about that? I know I was involved in working on this. I thought it was fine. I think we've had good feedback from the public concerning it. I also had some feedback, people, both good and bad, because I highlighted this in sort of the chair's report, just to be timely. And I had several people, including some of my colleagues at University of Washington, particularly those at Fred Hutch as well, because they go back and forth, because Fred Hutch is part of our institution, that they really were very pleased with some of the language changes that we made, particularly with people with longstanding chronic pain that's not in that. So any comments about that? Any edits for that report? Anyone over there on the internet that we see virtually? So can I have a motion to approve the edits document?
So moved.
Second? Second. Okay, all in favor, say aye. Raise your hand. All opposed, say nay. Raise your hand now. Good. April got her hand off. That was completed. Okay, so we've approved that for adoption. And that will then move us on for the rule making, is that right? Because that was an interpretive statement. What would that do?
So the interpretive statement in this case will still stay in place.
Yeah.
It will be brought into the rulemaking that we're working on for now.
Okay. So then we have opioid prescribing and monitoring of patients, also the interpretive station, it's completed Department of Health. Secretary review, commissioners will need to review and approve or deny suggested edits. The suggested edits are approved, commissioners will need to consider approving for adoption. Any comments about that? Right, and we have well, I assume that we want to, since that the suggested edits, we want to see if someone can make a motion to approve the suggested edits.
I so moved.
Second? Second. Okay, all those in favor, say aye.
Aye.
Raise your hand. All those opposed, say nay. Raise your hand now. All right, that's been approved. All right, there's a policy, visiting student learning opportunity license exemption. This document is completed by the Department of Health Secretary review. Commissioners need to review and either approve or deny the suggested edits. If the suggested edits are approved, commissioners will need to consider approving for adoption. Any discussion on this item? Anyone virtually? No, seeing none. Can we have a motion to approve these suggested edits? So moved. Second?
Second.
And then all in favor, say aye. Raise your hand.
Aye.
All opposed, say nay. Raise your hand now. Okay, that passes as well. Right, we will move on to the policy committee report. Ms. Blake.
Thank you. Thanks, Dr. Dunham. Hopefully you've all had a chance to review this prior to this meeting. I know that there's one document on here that we asked for input ahead of time, and I see that we got a lot of that. So I'll start first with the request for volunteers for small work group on medical marijuana authorization guidelines. Mike, I'm gonna try to, sorry, didn't mean to catch you minutes up there. If you wanted to talk a little bit more about this.
Thank you. So this is a request for volunteers from the commission. I just want to clarify that. Every so often, the department takes a global approach with respect to the healthcare boards and commissions to look at and revise medical authorization for cannabis. The last person who participated was Dr. Harrison, who was a pediatrician. And so we're needing volunteers to relook at these guidelines, considering new evidence of research, and come out with a consistent set of guidelines for recommendation of approval or adoption by the various boards and commissions.
I had a question about it. We have marijuana that you can buy, right, in our stores, and there are a lot of medical uses for it. I've heard a number of lectures recently about particularly use in chronic pain medicine. It's very popular among other areas. And I assume that the medical part of it is for insurance coverage. Is that how it differs from someone just buying the you know, whatever, because there's THC and then there's the other substance and.
Yes, and that's the thing. So this is more about taxes. So there's a 25% tax per level on the Washington cannabis system. So you have your producer, your wholesale, your retail. And when you do medical, you get your exemption card and you get an authorization from a practitioner, you lose 2 of those levels of taxation. So that's the
So
draw.
it's less expensive for the patient.
Significant.
Yeah.
Yes.
Any other comments from virtually either? Okay, thank you. We don't need any other question on this except you're looking for some volunteers, correct? Thank you. The second item on the agenda is the practitioners exhibiting disruptive behavior policy. It was reviewed as part of its 4-year review process. And the committee would request reaffirmation of the changes as made. Does anybody have any questions or comments on this one? Seeing none, can I have by a show of hands those that agree with moving forward as noted? Any opposed? Thank you. Thank you, April. Any opposed? Okay. Next is the interactive and transparent development of evidence-based policies and guidelines. We took a look at this at our committee, and it was suggested that we defer this. We have a new policy chair coming on very shortly. And Mike, if you want to say something else.
Policy manager, you're going to be.
Manager, sorry. Oh, I'm sorry. Manager, okay. Thank you. So we're asking for deferral of this.
So moved.
Thank you, Dr. Fessler. The next document is the guidance document on medical professionalism. Again, reviewed as part of its scheduled for a 4-year review process. And we recommend also deferring this document for additional work as mentioned with the other one.
And this one in particular, we received some comments from the WSMA that we'd like to have the committee consider, so we're going to try to incorporate what was suggested.
Thank you. Next, we have the proposed joint guidance for retail IV therapy clinics. Now, I know there was a lot of input on this going back and forth and appreciate the work put in ahead of time. I'm going to turn it over for also to Mike and to with regard to the changes and considerations that were brought forward.
Thank you. So this is an attempt by the 4 boards to get a handle on the growing problem of IV hydration clinics popping up and the attendant legal issues. And the main issue is, Mr. Russ is the absentee medical director. We have cases involving this. MDs who agree to be a medical director at an IV hydration clinic or a med spa or wellness center that provides IV hydration therapy, and then not providing good supervision, and then potential violations of pharmacy regulations as well. We had a work group that met on this last year, involving a number of staff people, and Dr. Murphy and Dr. Jager came up with this draft. This draft was largely taken from the West Virginia joint statement. We did some research, and there are several states, more than several, who have already adopted statements, joint statements involving the same boards. So this draft, frankly, and we give them credit in, I think, the first footnote that West Virginia boards did a very nice job here. So that's the background. We saw feedback from the Board of Nursing. Board of Nursing staff provided some good feedback that we incorporated. The Board of Nursing itself is meeting today, I believe, to discuss and review this draft. The Board of Osteopathic Medicine and Surgery provided feedback. The Pharmacy Commission is meeting in 2 weeks to provide feedback, to review and provide feedback. And the Policy Committee met and made a few changes. If you look at the draft, you can see some of the changes, proposed changes I underlined. And there was an email discussion or feedback on, you look at number 5, adding statement about the history of physical that needs to be done. A statement, IV hydration therapy may not be appropriate for certain age groups, including children and the elderly. So there was one thought to put in age limits, and another thought, no, that's a little too specific for what we're doing, because you can really get into a lot of detail here. We're trying to be general, I think. I think you want to be general and provide guidance to reasonably prudent practitioners who are considering being medical directors, and not only medical directors, because this does cover nursing as well, and provide to practice good medicine and not just to take a paycheck and be a medical director and not know what's going on. So that's the bottom line. So I appreciate any feedback, and I should mention, this is a long process. You're not adopting this today. That's not the ask. We're asking you to provide feedback so we can go to the other boards and say, here's the latest iteration of the medical commission's view on this. And then this is going to come back after we get a final document or another draft with everybody's input, all the other 3 boards' input, come back to you, come back to the other boards for final approval. So this is one step in a long process.
I just had a comment, and I think this is great. One thing I just want to say, share, because I was sent from the commission to outside one of the suburbs of DC, maybe a month ago. It was in March, I guess, so it's probably 6 weeks ago. And it was a conference of the nursing board and the FSMB and the pharmacy board. And this was a big topic because one of the issues comes of compounding. And what's safe compounding? And sure, it's very different in the operating room where you're trying to use sterile technique, you're wearing masks, and it's under sterile conditions. Some of these facilities are just outrageous. Apparently, they're dirty. People may not know what they're doing in terms of compounding, particularly when you have, or they may not care. And I didn't read this thoroughly enough, but I just want to say it is on a big perspective on a national level. We also heard, I think a year ago, that they're from some meeting that from in Texas, they had a nurse who was administering the IV that was given to a patient on the basis of a doctor or some, some licensed practitioner who ordered the medications in it. It also included potassium, and ran in the IV infusion so quickly that the patient had cardiac arrest and died. So there are some serious issues out there regarding these in terms of knowledge and cleanliness and following appropriate procedures. And that a medical director who's pretty remote may not even know what some of these issues are.
Dr. Curry, you have your hand up.
Oh, yeah, thank you. I know we're early in the process, but I just had one specific comment. Is this a good time to make it or not? I couldn't tell from what Mike said.
Yes,
Yes.
go ahead.
Yeah, okay. Number 9, which has to do with standing orders, that practitioners should not issue standing orders for retail IV therapy. I just wanted to point out that once an order has been given to say give, I don't know, vitamin B12 or whatever their IV thing is they're doing, there's usually sort of a set of orders that might be saying, check this first, then do this, then do that, then afterwards check this. And those type of standing orders that are sort of roll forward from the original order to, do whatever it is that the practitioner wants them to do. I think that needs to be clarified because those actually are patient safety types of orders. So I think this was meant like standing orders, like, oh, just do whatever, like without maybe thinking about it. But does that make sense to you guys?
Yes, this was the fuzziest issue for me, Dr. Curry. I know that the statement in here is probably a little too broad. So I welcome feedback on a good way, a good, concise and clear way to make this make sense. So I know that standing orders there's a lot of different ways you can do that.
Mike, do you have a group that is going to get together on this, or are you just looking for more comments from outside of this committee? So we don't take up the whole.
I would, we can do this offline.
Okay, so do
I
you,
appreciate any help on this.
okay, yeah.
And we do have a group.
Okay, great. Then,
But I appreciate what Dr. Curry said, and I think we will work on number 9, what it was meant to address. And understand, these are not IV centers that are based in hospitals or based in clinics associated with hospitals where the patient goes in for IV therapy, gets a medical screening exam, has a physician there, and is getting IV therapy and medications that insurance pays for. What we're talking about is standing orders where the patient goes in and says, well, I'm fatigued, so I need IV iron and B12 in my saline IV. And oh, what's this that's longevity medicine? Well, I don't know what it is, but I want it. And they don't even ask for insurance. It's a cash-based business where, these small clinics, even the one where I was in a town of 8,000 people where there were more horses than people, they had an IV therapy clinic. And I looked at their protocols and asked the nurse, because there was no physician on site, I said, you give 40 milligrams of Toradol IV? And she goes, well, if it's indicated. And I said, well, the manufacturers of Toradol say 20 is the maximum dose. And usually 10 or 15 is equal efficacious for pain compared with 20. Why would you give 40? And she goes, well, we just do. And I'm thinking that's not safe medical practice. So that's what these standing orders were meant to address. The ones where the patients, order their own IV based on, do you want to look younger? Do you want to have more energy? Much like going through the McDonald's drive-through, which, is not the practice of medicine.
yeah, nature dictates otherwise.
Thank you.
Dr. Trescott has some input.
I appreciate what has been said. I was going to say, I think this document as it stands is a nice broad outline of expectations around these clinics. However, there's no way that these outlines these practices. There's no way. I mean, if we really wanted to, we would say what can't be in these IVs, what should be, what dose cutoff there is, there's so many things that could be involved. We had this little discussion about would we put specific ages or would we just put the real young and the real old? And if you look at what protocols are like in the hospital setting, they are much more specific on these kinds of things. I think this is a nice first step, but these things have to evolve to a much higher degree of safety. Unfortunately, I'm afraid that we're going to learn that by mistakes being made in the current setting, the current way they're being used. And I don't know how to incorporate all the safety that would be nice to have in there. So I'm just saying, I think this is a first step. And as such, I think it's really a good document.
Thank you, Dr. Trescott. I think Mike would appreciate you joining in that on his group. And thank you, Dr. Murphy, for your comments to
One question. So Mike, am I correct to assume that currently, in terms of business itself, the IV hydration clinic is not regulated by any entities.
Correct.
But it's the providers, the healthcare professional, that's individual license that are being regulated.
Correct. That's all. We have 4 boards involved.
Are there any other?
Just like that, thank you. I was just gonna comment, Dr. Chang, one of the reasons that Dr. Domino put this group together last year was because of that issue, because we know that we're going to have to coordinate with other regulatory authorities. As Mike will attest, it can be exhausting, to try and get everybody on the same page. But as Dr. Truscott was highlighting, as a first step, this is great. And I heartily, I'm really pleased that the other regulatory boards have kind of come and kind of seen the light and are engaged in this process. And it's not just the medical commission kind of out there on our own. And so I wanted to say a special note of thanks to Mike, because I know that this has been very involved and very time consuming. And again, I think that the first round of this that you're seeing now is excellent.
Mike, sorry. Oh, I just had one other thing. I was thinking about that meeting I attended. They were saying some of these, they're setting up at rock concerts. Okay, and so there's like no real facility, there's no ability to clean anything. I don't know if that's addressed in terms of facility in which they're doing these at.
Sophia Vergara, the actress, had one at her wedding reception. So guests, when they get tired at reception, they can go out and get IV hydration, then get back on the dance floor. What's wrong with that?
Well, I'd like to comment, if I may, to say that I am very grateful for the work that's been done. Mike and crew, I think it's just been amazing. I'd like to compliment you on, in particular, sections 4 and 5, which actually talks about the relationship that a provider needs to have and the evaluation before they write the order. And as opposed to, going down Las Vegas Boulevard and saying, man, that was a real bender last night. I need IV hydration, and walking in and getting it. So I want to compliment you on that. I also want to echo what's already said about section 9. Yeah, I think standing orders could be a problem, but I think I recognize the intent here, and I want you to know that I appreciate at least that you're addressing that part. So I compliment you for the hard work. It's a big job. I get it. It's also a profit motive out there that is not going to stop. And when people can see the money that can be made and the demand by the folks in the community, we do need to have some regulatory systems in place. So thank you for your work.
Just to clarify, I think a lot of this, especially sections 4 and 5 that you're talking about, came from the West, directly word for word almost from the West Virginia joint statement.
Good.
Thanks, Mike. Are there any other comments? So if you have any more input or you'd like to join this group, get in touch with Mike. And thank you very much for your input today. That concludes our report. Dr. Thomas.
Okay, we're now on to member reports. Anyone have any reports they want to give us? One on hands raised on virtual? Seeing none, we will move on to staff reports. Thanks, staff, for all your excellent work and your great reports. Just wanted to see if there are any further reports from staff that you'd like to tell us about. Seeing no hands raised, we'll move on to the AAG report. Ms. Carter.
Nothing for me today, thank you.
Okay, so then we'll do our last exciting thing, which is leadership elections. So the previously announced nominations for the following positions are Chair Terry Murphy, MD, Vice Chair Ed Lopez, PAC, and Officer at Large Alicia Bedura, MD. We can take nominations from the floor. If there's anyone who would like to make a nomination from the floor for any of these positions, please let us know. Speak now. I don't see any hands raised. So we would like to proceed with an election for these three candidates in these positions. Say all in favor, say aye, or raise your hand. And anyone opposed, say nay, raise your hand now. Well, we should clap for our newly elected chair and vice chair and officer at large. And that adjourns the business meeting.
Dr. Domino, I just want to thank you for all that you did as chair.
Well, thanks, everyone. As I said, it was an honor and privilege. I really appreciate it. It's wonderful to get to know everybody. It's been a little more difficult virtually, but we get it together enough that we can meet too as well.